Okay, so moving on to social media and related policies. Why are we concerned about employees' use of social media and the internet? We're concerned because they can use it to sexually harass or discriminate against other employees, because excessive use of social media or the internet for non-work related reasons can cause a problem with decreased productivity, with attention, with quality of work, with breaches of confidentiality, if social media postings are including potentially confidential information about your business, about your trade secrets, etc. We're concerned because of potential disparagement of the company, disparagement of coworkers, disparagement of vendors or customers, disparagement of your products or services by the employee using social media, using the internet, potentially damaging your brand, potentially damaging your reputation in a public forum. And obviously we're concerned about potential criminal activity as well. So these are all the good reasons why we're concerned and why it's appropriate for employers to have policies that effectively, and because of the law that I'm going to talk to you about, very carefully address our needs and protect our company, protect our employees, but at the same time respect the rights of the employee who potentially is using the internet or using social media. So we want to have electronic equipment policies, internet use policies, email policies, social media policies, and personal electronic device policies. All of these should be present in a good employee handbook. And I've worked on all of these policies many times with my clients. But beware. The reason that this is a very tricky area is, again, Section 7 of the National Labor Relations Act, protected concerted activity. Again, employees in an employer's workplace of any size, regardless of whether the workplace is unionized or non-unionized, employees have a right to protected concerted activity. Again, protected concerted activity is when employees take action or engage in communication for their mutual aid or protection regarding terms and conditions of employment. And the National Relations Board is very aggressive about making sure that employers' policies restricting use of email, internet, and social media don't in any way deter or infringe on your employees' rights to concerted activity. So one case that we have under the National Labor Relations Board is Purple Communications. And in Purple Communications, the NLRB held that employee use of email for statutorily protected communications, concerted activity, on non-working time must presumptively be permitted by employers who have chosen to give employees access to their email systems. If you let your employees use your email system while they're working, during work hours, you are presumptively required to allow those same employees to use your email system to communicate among themselves about their terms and conditions of employment on non-working hours. You don't have to permit them to do this during work time when you're paying them to work, but you must give them access to your email system to engage in concerted activity, to discuss terms and conditions of employment on off hours. So there's a presumption once you give access to email for work reasons that you will allow your employees to use that email system for concerted activity during non-work hours. Again, not something that people commonly do, not something that I find employers are commonly aware of, so beware. Some of the policies that we see in employee handbooks that have been found to be unlawful by the NLRB are quite common policies, and it's surprising and sometimes confusing. But under National Labor Relations Act law, the NLRB has found the following policies to be unlawful. A directive to employees to, quote, avoid harming the image and integrity of the company. Now you would think that that goes without saying. That's a very common type of directive to your employees. The reason the NLRB is looking at that and saying that could potentially restrict or chill concerted activity is because it's subject to interpretation by an employee that they can't post information on social media or email or use the internet to discuss terms and conditions of employment. Because discussion of those terms and conditions of employment may negatively reflect on the image and integrity of the company. So since it's subject to interpretation that could potentially chill concerted activity, the NLRB says, no, this is an unlawful policy. Another common policy that you would think would be perfectly appropriate, prohibition on employees posting online information about the employer that could be deemed, quote, material and non-public or, quote, confidential or proprietary. Again, the NLRB has held in this specific instance that this is language that is susceptible to an interpretation by the employees that would chill their concerted activity, that would chill their right to engage in discussion of terms and conditions of employment. So these are too broad, they're too general. The third example, again, something that is common, seems like an obvious policy that you would want to have, the NLRB has said is unlawful. It's a provision in an employee handbook stating that offensive, demeaning, abusive, or inappropriate remarks are out of place online as offline. Okay, I mean, give me a break. Obviously, we don't want our employees engaging in offensive, demeaning, abusive, or inappropriate remarks. However, as remarkable as it is, in that particular case, the NLRB found that this was too general and that it could chill concerted activity. Recent case, 2017 case, just the last couple of months. All right, here's what happened. Supervisor spoke harshly to an employee 2 days before a union certification election was to take place. The employee's Facebook post stated that the supervisor is such a nasty mother effer, don't know how to talk to people, F his mother and his entire effing family, what a loser, vote yes for the union. Okay, how would you like it if your employee posted this? You probably wouldn't like it very much. And in fact, you might terminate that employee under your harassment policy, which is exactly what happened in this case. The employer terminated the employee for violation of the company's harassment policy. Was that found to be unlawful by the National Labor Relations Board? Do you think so? Yes, indeed it was. Because, again, this was a discussion of, according to the NLRB, protected concerted rights, protected concerted activity, employees' rights to discuss terms and conditions of employment, to communicate for their mutual aid and protection. So it's unfortunate that he used this kind of language, but the NLRB says this posting does not lawfully give rise to termination. So what do? Very clear guidelines for all of your internet and social media related policies. Be clear that the rules do not prohibit concerted activity. Employees, here's something that you can say, employees may not blog or post during business hours. You can say there's no expectation of privacy when connected to the workplace. You can say that disclosure of trade secret information is prohibited. You can prohibit using company email addresses to register for social media sites. And again, you can prohibit non-work related use of email during work hours. You can prohibit the posting of false information, information that is not true about the company or its employees, customers, or vendors. It is advisable to provide specific examples of what is prohibited, such as discriminatory remarks, harassment, threats of violence. Mandate that employees keep company logos off their personal blogs and personal web page, and always identify a contact person to address questions about internet and social media policies. Again, we really need to scrutinize all of these internet and social media policies in our employee handbooks. Policies that seem to be obvious and common sense may in fact be unlawful, may chill concerted activity. There is a model social media policy that was issued by the NLRB some years back. I have modified that to some extent, and I use it with my clients. If anyone would be interested in seeing that model policy, feel free to reach out to me, and I'd be happy to share it with you.
My memory, Tamsin, is that first bullet point where policies say at the end of a policy, nothing stated in the social media policy shall be construed as violating your rights.
That is not a magic bullet.
Right. That you cannot safe harbor yourself just by putting that in there. The NLRB has said that is not sufficient.
It's not sufficient.
To state that nothing here shall be violating your rights is not sufficient.
That's right.
In and of itself.
I still recommend that you include it, but Gary makes an excellent point. That is not a magic bullet. That will not protect you.